In the summer of 1852, in a courtroom in Springfield, Massachusetts, 12 men sat in a jury box and listened. Not to testimony, not to evidence, but to the rhythmic ticking of a pocket watch. By the end of that summer, those same 12 men had rendered unanimous verdicts in 17 consecutive cases. An outcome so statistically improbable that it appears only once in the surviving court records of antebellum America. The watch belonged to Judge Caleb Harrington. And 3 weeks after his death, it vanished from the official estate inventory, leaving only a blank space where its description should have been. This is the story of that watch, and the theory that refuses to die. Springfield, Massachusetts, in the middle of the 19th century was a city of contradictions. Industrial mills lined the Connecticut River, their machines marking time with mechanical precision. Yet the city's legal system still operated on the rhythms of an older America, where a judge's word carried the weight of near-divine authority. The Hampton County Courthouse stood on Court Square, a Greek Revival building that spoke of order, reason, and permanence. Inside, justice was administered in a high-ceilinged courtroom where sound behaved in peculiar ways. Architectural historians have noted that the room's dimensions created unusual acoustic properties. A whisper at the judge's bench could be heard clearly in the jury box, while voices from the gallery seemed to dissipate into the plaster walls. It was here that Judge Caleb Harrington presided. Born in 1798, Harrington had served on the bench for nearly 15 years by the time our story begins. Court records describe him as meticulous, stern, and possessed of an unusual personal habit. He kept a gold pocket watch on a chain, which he would place on the bench before him at the start of each trial. Witnesses who appeared in his courtroom remembered its ticking. A sound that seemed to fill the spaces between words, between objections, between breaths. You could hear it during the silences, wrote one attorney in his personal diary, now held at the Springfield Historical Society. A steady, insistent rhythm that became almost hypnotic during lengthy proceedings. The spring and summer of 1852 were exceptionally busy for the Hampton County courts. A surge in property disputes, contract disagreements, and criminal cases meant that jury trials were held almost continuously from April through September. And something strange began to happen. In case after case, juries returned unanimous verdicts. Not simply unanimous guilty or not guilty verdicts, which were common enough, but unanimous verdicts reached with remarkable speed and often in defiance of what legal observers considered the weight of evidence. Court transcripts from that period contain unusual marginalia. In the margin of Commonwealth v. Thaddeus Morton, a clerk wrote, "Jury decided in 14 minutes, all 12 in agreement, despite contradictory testimony." In another case, State v. Pemberton and Sons, inexplicable unanimity, no dissent recorded. By July, people had begun to notice. A letter published in the Springfield Republican newspaper, and signed, questioned whether some influence beyond the presentation of fact and law might be affecting the deliberations. The letter was dismissed by the editor as the complaint of a disgruntled litigant. But whispers persisted. 3 jurors from different cases that summer later claimed, separately, that they had experienced unusual difficulty concentrating during deliberations. One man, a merchant named Samuel Oakes, told his pastor that he could not hold a contrary thought in his mind during jury discussions. Another, a farmer named Isaiah Webb, wrote to a friend that the sound of time itself seemed to dictate our considerations. These accounts would not surface publicly for years. At the time, they were private confessions, shared in confidence and then forgotten. To understand what might have been happening in that courtroom, we must step back into the intellectual atmosphere of 1852 America. This was the age of mesmerism. Franz Anton Mesmer's theories about animal magnetism had captured the American imagination in the 1840s. Traveling mesmerists demonstrated how rhythmic movements, steady sounds, or fixed gazes could induce trance-like states in willing subjects. By 1852, the practice had become so widespread that serious medical journals were debating its legitimacy. Could sound alone influence thought? The question was not absurd to mid-19th century Americans. Research into acoustics was in its infancy, and the relationship between sensory input and mental state was poorly understood. A pocket watch, particularly a large one, could produce a sound measured at approximately 20 to 40 decibels at close range. In a quiet courtroom, this would be clearly audible. More importantly, the sound would be rhythmic, consistent, and subliminal. Present but not consciously noted, like the ticking of a clock in a room where you're trying to sleep. Modern sleep researchers have studied the effect of rhythmic sounds on cognitive function. Studies have shown that certain frequencies and rhythms can indeed affect concentration, decision-making, and even susceptibility to suggestion. But these are controlled laboratory conditions, not a 19th-century courtroom. The theory, then, is this. Judge Harrington, whether consciously or unconsciously, whether through deliberate manipulation or mere coincidence, may have used his pocket watch to influence jury deliberations. The steady ticking, audible in the acoustic peculiarity of that courtroom, could have created a mild trance state. A reduction in critical thinking. A subtle pressure toward conformity and agreement. Is this possible? Perhaps. Is it provable? That's another question entirely. On October 3, 1852, Judge Caleb Harrington died suddenly at his home on Maple Street. The cause was listed as apoplexy, what we would today call a stroke. He was 54 years old. His funeral was attended by much of Springfield's legal community. Tributes praised his fairness, his legal acumen, his service to the Commonwealth. No mention was made of unusual verdict patterns. No suggestion of impropriety marked his eulogy. The settlement of his estate followed standard procedures. An inventory was commissioned, listing all property, valuables, and personal effects. His law books went to the County Bar Association. His furniture was divided among relatives. His papers were archived. And here the story takes its strangest turn. The inventory, preserved in the Hampton County Probate Court records, contains a blank space. Item 47 is missing. The numbering continues, item 46, then a gap, then item 48. But 47 is simply absent. No description, no valuation, no disposition. Court historians have examined this document extensively. The blank is not a clerical error. The paper shows no signs of erasure. The ink continues without interruption on either side of the gap. It is as though the clerk began to write something, then stopped, leaving nothing but white space where an entry should be. Local legend holds that this missing item was the pocket watch. No one can prove it. But no pocket watch appears anywhere else in the inventory, and Harrington was known to have owned one of significant value. Where did it go? Why was it excluded? Was it removed before the inventory was taken? Or did someone deliberately leave that space blank? In the years following Harrington's death, the pattern of unanimous verdicts ceased. Juries in Hampton County returned to normal rates of disagreement, hung juries, and split decisions. Some jurors who had served under Harrington began, privately, to share their experiences. By the 1870s, when most of them were elderly men, a few spoke more openly. Samuel Oakes, the merchant, told an interviewer in 1876 that he believed something unnatural had occurred in that courtroom, though he could never articulate exactly what. The story became part of Springfield's folklore. A curiosity mentioned in local histories. A tale told by tour guides at the historic courthouse. In 1923, a researcher named Margaret Hendricks attempted to track down the missing watch. She interviewed descendants of Harrington's family, searched estate sales records, and contacted watch collectors throughout New England. She found nothing. Her unpublished manuscript, The Mystery of Judge Harrington's Timepiece, resides in the Springfield City Library archives. 50 pages of dead ends and speculation. So what can we actually know? We know that Judge Harrington owned a pocket watch. Multiple sources confirm this. We know that unusual verdict patterns occurred during his tenure, particularly in 1852. Court records document this clearly. We know that some jurors later claimed they experienced difficulty with independent thought during deliberations. Their statements exist in letters and diary entries. We know that the watch does not appear in his estate inventory, and that a blank space suggests something was deliberately omitted. The document itself is evidence of absence. What we don't know is causation. We don't know if the watch actually influenced anyone. We don't know if Harrington was aware of any effect, or if one even existed. We don't know why the watch was excluded from the inventory, or even if it truly was the missing item 47. Correlation is not causation. Unusual verdict patterns could have resulted from any number of factors. Social pressure, local politics, the particular composition of jury pools that year, the selection of cases heard, or simple statistical variation. The acoustic properties of the courtroom are real and documented. But whether they actually affected cognitive function in any meaningful way remains speculation. And yet the story persists. What we're left with is a mystery defined by what's missing. A blank space in a ledger. A watch that vanished. An explanation that will never be found. Perhaps Judge Harrington was a man ahead of his time, who understood something about sound and psychology that wouldn't be formally studied for another century. Perhaps he was simply a judge with a watch, and everything else is coincidence elevated to conspiracy. Or perhaps the truth lies somewhere in between. In that uncertain space where folklore meets history, where documented fact gives way to collective memory, where the absence of evidence becomes its own kind of evidence. The Springfield judge's watch may never be found. The estate inventory will always contain that blank. And 12 men who sat in a jury box in 1852 will keep their secret, if they ever had one to keep. What remains is the question. Not what happened, but what might have happened. And why we find that possibility so compelling. In the end, perhaps that's what all such stories offer us. Not answers, but the space to wonder. To question what we think we know about power, influence, and the hidden mechanisms that shape our decisions. The ticking has stopped. But the question remains.